Assalamualaikum to my lecturer, Professor Madya Dr. Haji Muhammad Shahnawi bin Muhmad Pirus. My name is Muhammad Khairul Haikal bin Khairul Azman. I am from class MC 2473A. And today I will be presenting about industrial relation law case Mazuna Begum binti Kadir Mira against Malaysia Airlines Berhad. This case is awarded number 196 of 2024. A little background on Mazuna Begum. She originally joined Malaysia Airlines System Berhad in 1992. Following the company's restructuring, she accepted a new employment offer from Malaysia Airlines Berhad on 1st September 2015 as a leading cabin crew, aka leading stewardess. She served in this position with a clean disciplinary record until the incident in question. As part of Malaysia's national COVID-19 immunization program, the Malaysian Aviation Group (MAG) introduced a COVID-19 immunization policy dated 6 July 2021. This policy made vaccination mandatory for all employees, including cabin crew like Mazuna, to ensure workplace safety. However, Mazuna expressed concern over the possible side effects of the vaccine, claiming a right to bodily autonomy. However, she did not produce any medical reports or exemption to justify her refusal, despite the company providing medical assurance and an opportunity to address concerns. She maintained her decision not to comply with the policy, not taking the vaccine. On 20th August 2021, Mazuna was issued a show cause letter citing insubordination for failing to comply with the vaccination policy. She responded by reiterating her stance but offered no medical grounds. The company, citing the serious health risks and need for compliance, terminated her employment effective 13th September 2021. After that, Mazuna brought her claim before the Industrial Court under Section 20, Subtopic 3, arguing that her dismissal violated her basic rights and was discriminatory. She sought reinstatement, asserting that she had been unfairly treated for exercising her freedom to refuse medical treatment. Moving on to the issues of the case. The first is, was the claimant's refusal to comply with the company's vaccination policy an act of misconduct warranting dismissal? The core issue was whether Mazuna's refusal, in the absence of a medical exemption, amounted to insubordination and a serious breach of company policy, particularly considering her role in ensuring passenger safety as cabin crew and as leading stewardess or as leading cabin crew. The second issue is, was the dismissal executed with just cause or excuse as outlined under Section 20, Subtopic 3 of the Industrial Relations Act 1967. The court examined if the company had acted fairly and reasonably in dismissing Mazuna and whether her actions viewed in the context of a public health crisis justified termination under industrial jurisprudence. The Continuing to the judgment of the case, the court held that Mazuna was guilty of insubordination and breach of company policy. The court found that Mazuna's persistent refusal, even after medical clarifications were provided, constituted insubordination. It emphasized that all employees have a duty to follow lawful and reasonable orders, especially during a health emergency like COVID-19. Dismissal was with just cause or excuse as her conduct jeopardized workplace safety, given the risk posed by unvaccinated personnel in customer-facing roles during the pandemic, like a cabin crew, especially a leading cabin crew, aka a leading stewardess. The court held that her refusal undermined the company's duty under the Occupational Safety and Health Act (OSHA) 1994, Section 27, Subtopic 1, Page A, to maintain a safe workplace. Claimant's argument on personal rights was rejected due to the overriding public interest during the pandemic. While individual autonomy is respected, the court ruled that it must yield to public interest during a pandemic, citing the principle "salus populi suprema lex", the welfare of the people is the supreme law. The court held that collective safety outweighed personal choice. Continuing to analysis and critics, the final section, The first one is balancing individual rights versus public safety. The case highlights the tension between personal autonomy and societal responsibility. While Mazuna invoked her right to refuse vaccination, the court emphasized that in the context of global pandemic, public health considerations takes the importance key, take precedence. Number two, lawfulness of the employer's policy being reasonable and lawful under, under OSHA 1994 Section 27 1A. The company's vaccination directive was deemed lawful under Occupational Safety and Health Act (OSHA 1994), which requires employers to ensure the health and safety of employees. The Malaysian Aviation Group, the MAG policy, was aligned with the National Immunization Programme (NIP) and aimed at protecting both staff and the public. The third one is duty of obedience and workplace conduct. In subordination, employees are obligated to comply with lawful and reasonable directives. The court reiterated that employees must comply with directives that are lawful and reasonable. Refusal without valid justification, especially in safety critical roles like cabin crew, especially leading cabin crew, which Mazuna Begum has been employed to, constitutes serious misconduct. The court's rejection of discrimination claims, vaccination policy was uniformly applied to every staff. Mazuna's discrimination claim was dismissed as the policy applied equally to all employees. The pilots, the cabin crews, the other stewards, the leading steward, the supervisors, and everyone on ground. No evidence showed that she was singled out, and others without exemptions were also subject to the same rules. Proportionality of the dismissal. The court held that dismissal was proportionate considering the circumstances. Mazuna's role required direct public interaction, and her refusal posed a safety risk towards the public. Her unwillingness to engage constructively also contributed to the severity of the sanction. The last but not least, application of industrial law principles. The court applied established industrial law principles, including the burden of proof on the employer and the standard of balance of probabilities. The decision was rooted in fairness, equity, and public interest, consistent with Section 30, Subtopic 5 of the Industrial Relations Act. And there we go. Here are some references I used for this slide creating and the background research of the case. And the first one is from the Industrial Court of Malaysia, from where I get the case. The second one is from Industrial Relations Act 1967. And the third one is from Occupational Safety and Health Act 1994. The fourth one is from Federal Constitution of Malaysia, Article 9. And the fifth one is from Malaysia Aviation Group themselves. And the sixth one is from Ministry of Health Malaysia about COVID-19, the NIB program. The seventh one is from Ministry of Human Resources, facts on COVID-19 vaccination and employment. And that is all from me. Thank you.